Good evening everyone, welcome to Bajirao IAS Academy. So we have been discussing important topics for mains examination from polity subject, and today we will be discussing some more important topics with respect to judiciary. And firstly, we will be discussing about the need for virtual courts, or it is also known as e-courts. And in fact, particularly after the COVID-19 pandemic, the demand for e-courts has been increased enormously. So therefore, in this context, there is a high probability of asking questions from this particular topic, that is the need to make a transition towards virtual courts or e-courts. So in one of its judgment, the Supreme Court has actually invoked Article 142. Remember, we have already discussed what is Article 142. So this talks about the power of Supreme Court to do complete justice in any case under its consideration. So therefore, the Supreme Court has invoked Article 142, and in fact, the Supreme Court has also passed directions for all courts across the country to extensively use video conferencing for judicial proceedings. So therefore, this is part of a large-scale adoption of the e-courts project. So that is the way to make a transition into the virtual courts. However, why the Supreme Court has been stressing on the need to make a transition towards virtual courts or e-courts? So it has a number of benefits or advantages. So first, we will look into the benefits or advantages of making a transition into the virtual proceedings. Firstly, it will address the pendency of cases. So we have discussed in our previous classes, there are around 4 crore cases pending across various courts in India. So therefore, pendency of cases is one of the problem that judiciary has been facing. However, it is expected that through virtual courts, the pendency of the cases can be substantially reduced, because online judicial services can help, can assist, or can aid in clearing the backlog of the cases at the reduced cost and even with a lesser time as well. So this is the first benefit of making a transition towards the virtual courts. Second benefit is that it would substantially reduce the paperwork across different courts, and in fact it promotes digitization of the court proceedings as well. So therefore, when digitization of the court proceedings takes place, it would help the court staff and court focus on its judicial functions only. Thereby, we can say that the efficiency of the judicial proceedings would substantially increase by reduction of paperwork, and judicial staff would also start focusing on the judicial functions as well. And in fact, it makes the real-time data available, and it would lead to the evidence-based or data-driven policy making. Remember, evidence-based, data-driven judicial decisions are very important, right? So in fact, availability of huge data would result in better case categorization and also effective monitoring by the high courts on the subordinate courts as well. And in fact, Indian judiciary has been facing the problems with respect to inadequate infrastructure, and in fact it is very important to address the problem of inadequate infrastructure. However, this problem can be addressed by the virtual courts, because virtual courts don't require the physical infrastructure, and apart from that, it also significantly reduces the cost involved in it, and it also significantly reduces the manpower requirement as well, and it also reduces the financial constraints as well. So therefore, it could address the infrastructure constraints as well, because in virtual courts, most of the judicial proceedings would take place through audio and video hearings, and that would substantially reduce the need for buildings, other infrastructure, staff and security as well. So therefore, this is another important reason that why we should shift towards virtual courts, or why there is an increased need for the virtual courts. And apart from that, due to a recent instances of corruption in judiciary, And apart from corruption, there are instances of nepotism as well, and in fact judiciary is not under the RTI as well. So therefore there is a need for increasing accountability into the judiciary to reduce corruption, to reduce nepotism, bring in more accountability and transparency. However, it is well known fact that whenever there is an increased digitization, that would bring in increased accountability and transparency. So therefore the audio video recordings that actually takes place in these virtual courts, so that actually result in increased transparency and accountability in the court proceedings. So therefore this also another big advantage of making a transition into the virtual courts. Similarly, data management would be another important area, and this data management would help us understand different aspects within the judiciary. For example, the judicial vacancies can be understood, the number of cases filed on particular categories can be understood, and how much time has been taking for resolving these issues can be taken place. And in fact all the judicial data can be put in the public domain, so therefore public would be better informed about the state of the judiciary as well, and therefore that would substantially increase trust and goodwill of the people on the judiciary. And in fact it also promotes proactive participation of people in making judiciary more responsible, transparent and accountable as well. So therefore these are some of the advantages of making transition towards the virtual courts. However, making a transition towards virtual courts also comes with certain challenges. So let's try to discuss some of these challenges. So what challenges we would face when we make an effort to make a transition from physical courts to virtual courts? The first challenge is of course physical constraints, or it is a financial constraints is a first problem, because deployment of new age technologies such as high speed internet, latest audio and video equipment, cloud computing, all these technologies require financial costs, or it requires a huge amount of money spent on these aspects. And initially infrastructure also required, financial infrastructure, digital infrastructure is also required to support all these virtual courts or e-courts. So therefore this could be one such challenge. The second challenge could be human capacity. Remember one thing, that India is facing the problem of digital divide, or I would say digital illiteracy is a big problem that India has been facing. So therefore lack of technical skills of court staff and absence of dedicated house technical support are the other major challenges that India has been facing. And another major problem is digital divide. So digital divide in the sense that, so you can easily see there's a huge difference between rural and urban population in terms of access to the digital devices, access to internet, access to technologies. And similarly there is a huge difference between the male and female when it comes to access to digital devices, access to internet and mobile phones. So this is what is known as digital divide, and digital divide is another major problem that India has been facing here. So therefore non-availability of electricity is another major problem. So even though the government has made a remarkable progress in terms of electrifying all the villages in India through number of programs such as Saubhagya, so all those programs have made electricity accessible to every village, but there are problems with respect to access to electricity. And even internet connectivity is another major problem that most of Indian villages have been facing, right? So even though the government has launched a program called BharatNet, I hope you knew about this BharatNet program. So this focuses on broadband access to every village, right? So this program focuses on broadband access to every village. So still there are problems with respect to access to electricity, access to internet, access to mobile phones, right? So therefore it creates a huge inequalities when it comes to access to justice, inequalities when it comes to access to justice. So the overall purpose of creating virtual courts or e-courts is to ensure access to justice, for the people who are living in remote and rural areas who may not be able to travel to far off places to attend the judicial proceedings. But the problem here is that the digital divide is main problem, and digital illiteracy is another major problem, and lack of access to electricity, lack of access to internet are the main problems which are resulted in this. And similarly, we do not lack we are lacking skilled manpower, right? So skilled manpower is lacking, and we also don't have the common service centers, particularly the functional common service centers in each of those villages. And BharatNet is not yet fully covered all the villages in India with the broadband access. So all these problems still remain, and these problems further make the transition into virtual court mode would be further difficult, right? So apart from that, low awareness also with respect to the virtual courts. According to a data released by PRS, so it says that only 40% of the cases were filed exclusively through the computerized system. So this has been indicating that there is a lack of awareness, there's a lack of knowledge among people how to use the digital mode of filing cases or how to use the virtual courts. Now, in order to make these virtual courts more and more success, it is very important that we need to run information, communication and education campaigns. So ICE campaign has to be conducted so that people would have adequate awareness about these virtual courts, and people would also start filing cases through the virtual mode as well. And apart from that, we are living in a new age of technology. So in a new age of technology where technology has made our lives easier, similarly technology has also resulted in some problems, particularly the cyber security issues. For example, the cyber crime is on rise in recent times, right? So cyber crime has been increasing. There are issues like ransomware, issues like deep fake and hacking. So all those problems that we have been facing when it comes to the cyber crime. So therefore, the personal information, financial information of people is being illegally taken away. And in fact, there are also attacks on critical infrastructure in India and other countries also. All these things have raised serious concerns, and this is also another major problem when it comes to judiciary's efforts to make a transition towards virtual courts. And even there are some procedural problems also when it comes to the deep fake and edited audio video. So all these things can actually mislead the proceedings. So therefore, when we are able to address all these problems, we could ensure that the virtual courts project would be more successful. However, we also taken some efforts with respect to digitization of the court proceedings, and also bringing in the aspect of virtual courts, because after the COVID-19 pandemic the need has been felt that okay, we need to make a rapid and a faster transition towards the virtual courts. So because of that reason, some initiatives are also launched. For example, LIMS initiative. So LIMS is Legal Information Management and Briefing System. So through LIMS, the court orders can be transferred to the law enforcement agencies at a much faster pace without any delay. And in fact, a re-engineering committee on high courts has been started, National Judicial Data Grid has been started, and e-courts mission mode project has also been started. And in fact, all these initiatives primarily aimed at ensuring that Indian judiciary make a rapid transition towards virtual courts, or what we can say e-courts. Now e-courts or virtual courts have multiple advantages such as access to justice, particularly for the people who are considered as poor. Now remember that Article 39A of the Indian Constitution, it is Directive Principles of State Policy. So it talks about equal justice and free legal aid. Equal justice and free legal aid. So therefore, in order to achieve this equal justice and free legal aid directive principle, so it is certainly very important to bring in the concept of e-courts. So therefore, justice could be accessible to everybody. So according to some data that has been released by the ministry, so around 700, more than 700 people have access to internet in India, or they are using internet in India, and in fact this number could also further increase. So in this context, what needs to be done? Information, communication and education campaign has to be taken up on a large scale for the dissemination of knowledge about the e-courts project. And in this context, National Legal Services Authorities Act, so that could be effectively used, so that awareness on e-courts further increase, and it will result in achieving this goal of equal justice and free legal aid that has been part of Article 39A of the Constitution, particularly that has been enshrined through 42nd Constitutional Amendment Act. And what should be the way forward to make the virtual courts or e-courts project a resounding success, right? A set of measures have to be taken up. First, digital infrastructure has to be created, right? So with virtual courts, physical infrastructure such as buildings, security system, staff, so all these things are not required. But when you are creating virtual courts or digital courts, so of course it requires digital infrastructure, right? So as I have already told you that common service centers should be created, right? So like almost in every village, common service center should be created, so that people could easily access the services. Particularly people could be part of the virtual courts, right? So they could be part of the virtual courts, and common service centers should facilitate e-filing of cases, or I would say filing of cases, and they should facilitate video conferencing as well. So all these services has to be provided through the common service centers. And similarly, capacity building is also very, very important. Capacity building in the sense that the court staff should be adequately trained. Training should be provided to the court staff on these virtual courts. And apart from that, the online courses for judges, online courses for the staff, and even courses and training on the management and maintenance of the electronic data that has been generated. And similarly, creation of a skilled manpower is also very, very important. Skilled manpower should be created in the judiciary, so that the skilled manpower could actually form a foundation in the judiciary, particularly to make a transition towards the virtual courts or e-courts, And even there is a need to amend rules for the use of electronic evidence, right? So in fact, courts should accept the electronic evidence. So even though courts have been accepting electronic evidence, but there is a need when you are making a transition to physical courts to virtual courts, so there are some changes that have to be made, that could be resulting in more acceptable form of electronic evidence. So therefore, creating a user-friendly e-courts mechanism and awareness generation, this is also another important aspect. And data privacy rules to prevent the breach of data and also ensure privacy of people. Remember, right to privacy is part of the fundamental right, because in Puttaswamy judgment the Supreme Court has held that right to privacy is part of Article 21 of the Indian Constitution. So therefore it is the responsibility of the judiciary to protect the privacy of the individuals as well, and also take steps that that would result in data should be adequately safeguarded, data should be adequately protected as well, right? So these are the measures that the court has to take in, has to be the court has to follow, or the court or the government should adopt, so that would result in faster and rapid transition into the digital or digitization of the court proceedings. So the next topic is fast track courts. So we'll understand some important aspects with respect to fast track courts. So these fast track courts are also regularly in use, and it is also very important. So therefore we'll try to discuss about this as well. Now, what are these fast track courts or special courts? Right, so fast track courts or special courts are ad hoc institutions, right? So ad hoc institutions are any institutions which are temporary in nature, right? So they are temporary in nature, and in fact these fast track courts or special courts are established to established for any specific or particular purpose, right? So they deal with a particular type of cases under a shortened and simplified procedure. For example, ad hoc courts set up to deal with cases involving POCSO cases, right? Protection of children from sexual offenses, right? So in fact fast track courts or special courts are being set up for for the cases of criminal politicians, to try cases of criminal politicians. Fast track courts or special courts are established. So understand the idea is that these special courts are established to deal with a particular type of cases, right? So they specifically deal with the particular type of cases whenever the government felt the need that so this case has to be dealt by a special court, this case has to be dealt by a fast track court. So then these special courts or fast track courts are being established so that the trial could take place at a faster pace, and justice can also be delivered in a limited period of time. So that is the overall objective of setting up the fast track courts or special courts, right? So therefore in India pendency of cases is huge, right? There's a huge pendency of cases, and similarly there are also judicial vacancies also as well, judicial vacancies, pendency of cases. So because of pendency of cases and judicial vacancies, what has been happening, so there are some important and very sensitive cases. For example, crime against women, right? So crime against women, so justice is not delivered to the victims in a time bound manner. And crime against children, crime against women, so justice is not delivered in a timely manner or time bound manner in these cases. So therefore there is a need to establish fast track courts or special courts has been felt, and that's why these courts are established. So I hope you have understood this overall idea, and now we'll proceed on to discuss these fast track courts and the evolution and the history of these fast track courts as well. Now in Indian Constitution there is a particular article that specifically deals with these fast track courts or special courts. That article is Article 247. So Article 247 deals with special courts or fast track courts, particularly the power of Parliament to establish such courts, because they have a special purpose, or they are a particular type of they actually deal with a particular type of cases, right? So in fact Article 247 of the Indian Constitution talks about the power of Parliament to establish certain additional courts. So Parliament have the power to establish certain additional courts apart from the courts that we already have, and these additional courts are established for the better administration of laws that are created by the Parliament or any existing laws with respect to the Union Parliament, right? So this is what Article 247 has been talking about. And in fact, the Ministry of Law and Justice, and this particular ministry has launched a scheme for setting up around 1023 fast track courts. So this has launched a scheme for setting up around 1223 fast track courts specifically to deal with cases of rape and POCSO Act, cases of rape, POCSO Act, crime against children, crime against women, as part of National Mission for Safety of Women. So what happens with creation of such a fast track courts? So justice will be delivered in a time bound manner, and that is the idea of setting these fast track courts or special courts. And in fact, from time to time, finance commissions have also been making recommendations to establish these fast track courts. For example, the 11th Finance Commission, so in the year 2000 recommended to establish 1734 fast track courts. So why the Finance Commission has recommended to establish such a huge number of fast track courts? To deliver speedy justice, right? To deliver speedy justice in pending cases, particularly under trials in the lower judiciary. And secondly, 14th Finance Commission also made a similar recommendation to establish 1800 fast track courts, right? So 1800 fast track courts. And in fact, the 14th Finance Commission has also urged the state, all the states, to utilize the enhanced devolution of central taxes of 42%, right, to fund this effort. Now in fact, the devolution has been increased to the state governments under the 14th Finance Commission, and because of that particular reason, the 14th Finance Commission has asked all the states to make efforts to set up or establish more and more fast track courts in India, so that it will result in access to justice and speedier delivery of justice as well. And it also results in reducing number of under trial prisoners. So that is also a human rights issue, because in India there are more under trial prisoners and it leads to their human rights. So therefore, what are the advantages of these fast track courts? So let's try to understand the advantages of the fast track courts, because fast track courts have a set of advantages, and that's why there is a need felt to establish these fast track courts. So firstly, these fast track courts obviously reduce the pendency of cases in the judiciary, because remember, we have discussed that in various courts, Supreme Court, High Court across various states, and subordinate courts at the district level, and all other subordinate courts, so around 4 crore, more than 4 crore cases have been pending. Now imagine that such a fast track courts or special courts are established. Now these fast track courts or special courts would deliver justice in a quick period of time. So therefore, they play a very important role in dispute resolution, and they also quickly reduce the pendency of the cases, thereby reducing the burden on the judiciary, So therefore, one advantage is that it would reduce the pendency of the cases, because fast track courts already solved millions of cases and this will substantially reduce the burden on the judiciary. So what is the burden on the judiciary? The burden of increasing pendency of cases, and increasing pendency of the cases would result in inefficiency within the judiciary. So secondly, it plays a very important role in further enhancing judicial efficacy as well, right? So as we have just discussed that increasing pendency of the cases would result in reducing efficiency of the judiciary. So therefore simplified procedure would be adopted by these fast track courts or special courts. So the simplified procedure, and even there is a chance for high clearance of cases in the fast track courts or special courts, would result in the speedy trial, and that overall increases judicial efficacy. So increasing judicial efficacy means that justice will be delivered in a time bound manner or in a timely manner, right? So that substantially enhances or strengthens trust and goodwill on the judiciary. And similarly, the fast track courts or special courts would promote specialization, right? So in fact these courts play a very important role in promoting specialization, because remember that these fast track courts or special courts are dealing with a certain type of cases: crime against women, crime against children, and criminalization of politics. So therefore experts are required to hear these cases and deliver justice. So therefore, don't you think that these fast track courts, when they are dealing with the special type of cases, it promotes specialization, because they are established to handle the specific types of cases. So therefore it could enable the appointment of experts in that field as judges. And secondly, apart from that, it would also result in more consistency and predictability as well, because fast track courts have high performance rates and they are also stable and steady, and it renders justice with a high accuracy. And that is the advantage of establishing these fast track courts. And similarly, establishing fast track courts or even special courts would result in it act as a deterrent effect. Now what is a deterrent effect? So deterrent effect in the sense that since justice has been delivered in a very quick period of time, and trials takes place in less than a year, because in Indian judiciary cases are pending for more than 20 years. So therefore this actually provides a free pass to a lot of offenders to escape escape this judicial process, this lengthy judicial process. So therefore when cases are heard in a time bound manner and justice is also delivered in a time bound manner, there is a high chance that it would actually act as a deterrent among those regular offenders, right? So therefore it would result in reduced crime as well. So speedy justice actually acts as an effective deterrent, and that would reduce crime in the society. And similarly it also substantially increase effectiveness of the judiciary. So when we talk about increasing effectiveness of the judiciary, speedy justice would result in enhanced efficiency and effectiveness of our judicial system, thereby promoting people's confidence in the justice delivery mechanism as well. So therefore as of now, judiciary is criticized for lack of transparency and in fact lack of access to common people, particularly the poor. So therefore a speedy justice would enhance efficiency of the judiciary. It would reduce the pendency of the cases. It would increase the effectiveness and efficacy of the judicial system, and that actually plays a very important role in promoting people's confidence in justice delivery mechanisms in India. So however, these fast track courts are or special courts have been facing number of issues as well. Now what are the issues these fast track courts or special courts have been facing? Now first problem is that there are insufficient number of fast track courts. So fast track courts are not created in a large numbers, and in fact they actually have a huge number of cases to handle. And in fact fast track courts are created, but it also has a huge vacancy of judges as well, right? So for example, Delhi fast track courts have only 1 or 2 judges. So with 1 or 2 judges in these fast track courts, it will be very difficult to hear these cases and deliver justice in a very quick and time bound manner. So therefore there is an urgent need to set up more fast track courts along with filling the judicial vacancies that are existing in these fast track courts, so that they could actually deliver justice in a time bound manner or timely manner. Secondly, the fast track courts also have a heavy workload, because remember, less number of fast track cases, so less number of fast track courts and more number of cases that they need to handle, and even vacancies existing. So therefore all these things have resulted in heavy workload, right? So it has resulted in heavy workload. So therefore increasing cases are being assigned to these fast track courts without increasing number of judges to hear these cases in the fast track courts. So therefore that has increased the pendency of cases in these fast track courts, because as per PRS data, held that 5.9 lakh cases have been pending in 581 operational fast track courts. So 5.9 lakh cases pending in these fast track courts is actually not a small number, right? So despite these fast track courts have been established, they again facing the problem of pendency of cases. So there is a need to deal with the issue of pendency of cases. Secondly, no special or a speedier procedure adopted in these fast track courts or special courts, and that has been resulting in the pendency of the cases, right? So usual delay like regular courts that have been taking place in these fast track courts, because National Crime Records Bureau data has been revealing that 78% out of 28,000 trials done in these fast track courts, they actually took more than 1 year to finish the trials. So therefore this has been indicating that there is a delay in these fast track courts also when it comes to delivery of justice. And fast track courts are also facing a lot of problems, right? So inadequate, insufficient number of fast track courts, judicial vacancies, judicial pendencies, lack of infrastructure, lack of adequate number of judges, lack of the support from the government. So all these problems that these fast track courts have been facing despite creation of such courts. And similarly, fast track courts also lack the necessary infrastructure, right? So every court requires necessary infrastructure. For example, it requires a building, it requires a proper building, and it requires electricity, it requires security, it also requires other staff, management staff, it requires other essential infrastructure within the court. But the problem is that due to financial constraints or due to allocation of less or due to less budgetary support, so there is a lack of infrastructure within these fast track courts, right? Because fast track courts sometimes also conduct the video and audio recordings of the victims, and because of lack of infrastructure, it has resulted in the reduced effectiveness of these courts. And similarly, there are some financial constraints also existing within these fast track courts. In fact, Supreme Court in Brij Mohan Lal case has stressed on continuation of these fast track courts in the state domain with their funds. For example, as per PRS data, 56% of the states or union territories not yet constituted any of these fast track courts. So if states are not constituting the fast track courts, how can we expect that the cases are cleared by these courts in a very in a time bound manner or in a timely manner? Because states themselves are not interested to create these fast track courts, right? So in this case, in this situation, dependency of the cases would further increase, and lack of coordination is also another major problem, right? Because fast track courts and special courts, so they are actually under different judicial bodies, and sometimes there is a lack of coordination, lack of cooperation among all these fast track courts or special courts within themselves, and that also makes it more and more complicated for the for the overall functioning of these fast track courts. So what should be the way forward in this context? So there should be a way forward as well. So the way forward is that capacity building, right? So we should focus on capacity building, and we should also focus on improved infrastructure or improving infrastructure. So when we talk about capacity building, there should be skilled manpower, and training has to be provided to the judges and to the court staff, and appointment of the additional judges or ad hoc judges within the special courts, and making fast track courts permanent instead of ad hoc in nature, and dedicated courtrooms has to be provided, technological facilities. So therefore, overall, there is a need to rapidly improve the infrastructure of the fast track courts, along with more number of judges, dedicated courtrooms, and there is a need to make these fast track courts as a permanent courts, right? So that's how the pendency of the cases can be substantially reduced. And we could also use modern technologies such as big data analytics, artificial intelligence, because they could ensure a better grouping of cases, and the priority can also be decided so that the cases can be cleared in a prioritized manner by the fast track courts or a special courts. And similarly, cooperation between different departments, different cooperation between different fast track courts is also very, very important. Cooperation between center and state government is also very, very important for creation of infrastructure, and to deal with the financial assistance, etc. So states should engage with senior district judges to get a sense of issues courts are facing in various districts, and holistic approach has to be adopted. There should be a holistic approach, particularly police reforms to improve investigation, and even special procedure for a speedier disposal of the cases which have been pending before the courts, right? Because see, one thing that we should understand is that there is a delay in delivery of justice in courts, and there are more number of under trials in prisons, is because of a poor quality of investigation and lack of professionalism in our police system. So therefore, there is a need to focus on investigation. There is a need to bring in professionalism. So for that, there is a need for police reforms. We should focus on police reforms, and there should be a special procedure that must be adopted by the fast track courts for a speedier disposal of various cases which are pending within these fast track courts. There should be cooperation, there should be adoption of modern technologies, and there is a need for capacity building along with improved infrastructure. So the next topic is All India Judicial Services. So we'll try to discuss about this All India Judicial Services as well, because this is also a very, very important topic, and this is also in news very often. And because of that particular reason, there may be one question on this All India Judicial Service as well. So in fact, what is the constitutional sanction or status of this All India Judicial Service? So Article 312 So Article 312 of the Indian Constitution provides for the establishment of All India Judicial Service. And in fact, so it also says that this All India Judicial Service shall not include any post which is inferior to that of a district judge, right? So it would create, All India Judicial Service under Article 312 of the Constitution, and it says that creation of a post which is not below the rank of a district judge, and this is what is known as All India Judicial Service. Like how we have All India services, Indian Administrative Service, Indian Police Service, Indian Forest Service. So in similar way, there is also an idea to create All India Judicial Service, because judiciary has been facing number of issues, particularly vacancy, judicial vacancy, and pendency of cases. So therefore, in order to deal with multiple problems that the judiciary has been facing, in order to bring in efficiency within the judiciary, it is suggested to bring in All India Judicial Service, because All India Judicial Service would result in merit or meritorious people would be recruited as judges at the district level, and they would be promoted as judges of the High Court, judges of the Supreme Court in later stages. So since they are they are result of a competitive examination and they are meritorious, it would result in overall efficiency of the judiciary. It would result in reducing the pendency of the cases, and it would also fill the judicial vacancies. It enhances the it actually enhances the efficacy and effectiveness of the judicial functioning. So that is the idea behind the All India Judicial Services, right? And in fact, the provision Article 312 enables creation of an All India Judicial Service at the district judge level. However, in government's view, a properly framed All India Judicial Service is very important to strengthen overall justice delivery system. So it is expected that it will strengthen the overall justice delivery system. It enhances efficacy, it enhances efficiency of the judiciary, and it also strengthens goodwill, trust of the public on the judiciary, and it enhances access to justice, and it would result in fulfilling the goal of Article 39A of the Indian Constitution, Directive Principles of State Policy, that talks about equal justice and free legal aid, right? So in this context, we will understand what is the need for All India Judicial Services, right? So why we should have an All India Judicial Services? So one thing that you should understand here, as of now, we don't have an All India Judicial Services. However, the need has been felt because of the current state of Indian judiciary. There are demands that there should be an All India Judicial Service. Now, in fact, when we have an All India Judicial Service, so it could enrich the justice quality, particularly with respect to training and also innovation at work. So that enhances the judiciary when it comes to increasing efficiency and efficacy. So it increases efficiency because it is a well organized judicial service, and it is a recognition of merit, and it can also attract a lot of talent. So that is the second reason for supporting All India Judicial Service. And thirdly, addressing the judicial pendency of the cases, because around 3.5 crore cases have been pending across different courts in India, and in order to deal with the pending number of cases, we need to have the All India Judicial Service. And in fact, a judicial vacancy also, we have discussed all this, because more than 5,000 vacancies in subordinate courts, so that amounts to approximately 24%. So more than 24% of the judicial vacancies. So these judicial vacancies could be streamlined, and there should be an objective recruitment process, and that would result in good quality judicial officers for vacant posts. And similarly, transparent appointments. So transparent appointments is another area, because that could reduce nepotism, and that also ensures appointment of competent people. Now, one thing that we should understand here, when it comes to appointments, there is inadequate representation, right? So inadequate representation of women and people from backward classes, or judges from the backward classes. Inadequate representation from judges from the backward classes, and even women judges in the higher judiciary. So therefore, there is a need to increase the social representation of judges in the higher judiciary. The Supreme Court and High Court should have more women judges. Supreme Court and High Court should have more judges from the backward classes, right? This All India Judicial Service, since it selects district judges based on merit, there is a high probability of selecting judges from women. There is a probability of more number of judges from the backward classes as well. So thereby it would result in the transparency in the appointment of judges. And apart from transparency in the appointment of judges, when it comes to judicial appointments, so there is a criticism that nepotism is existing, and uncle judge syndrome is also existing within judiciary, right? So nepotism, favoritism, uncle judge syndrome is also existing within judiciary. So therefore, in order to deal with in order to make judicial appointments more and more transparent, there is a need for All India Judicial Service. And similarly, the quality of judges also, because most of the judges in the All India Judicial Service at the district level would be elected through a competitive examination. So that means a meritorious candidates would become district judges, and those district judges would be further promoted to the High Court. They would be further promoted to the Supreme Court, right? So this could prevent incidents like Justice Karnan, incidents like people like Justice Karnan becoming judges, and in Madhya Pradesh High Court, a judge asked a rape accused to tie a rakhi to the victim. So those kind of incidents could be effectively prevented when meritorious candidates become judges, when they are promoted to the higher judiciary. And even reservation could also be provided, and reservation would make more number of people from the backward classes would become the judges as well. So thereby it will ensure representation to all sections of the society as well. And apart from that, it would also result in cooperative federalism, because there will be a unified judiciary, a uniform laws, and an all India judiciary, and that would result in institutionalization of the idea of cooperative federalism that has been recommended by the Second Administrative Reforms Commission, National Commission to Review Working of the Constitution, and also the Niti Aayog. So all these bodies have recommended for institutionalizing the idea of cooperative federalism, and All India Judicial Services could actually institutionalize the idea of cooperative federalism. However, there are sort of challenges as well, right? So what are the challenges to this All India Judicial Service? So we should also discuss the challenges as well. So it could actually undermine the independence of the judiciary, because Article 233 enables High Court to appoint district judges, and in fact this All India Judicial Service transfer this power to the executive. So therefore this could actually undermine the independence of the judiciary. Now if you remember, National Judicial Appointments Commission 99th Constitutional Amendment Act has been declared unconstitutional by the Supreme Court because it violates the independence of the judiciary. And again, All India Judicial Service could also violate the or undermine the independence of judiciary. Similarly, division of power. Presently, Centre has no say in the appointment of district judges. So All India Judicial Service will lead to the duality of control. So it will lead to the duality of power, right? So similarly, there will be increased cost, such as law and order is a state subject and each state has its criminal and civil laws, and that would increase the cost of training as well. This could be another major problem with the All India Judicial Service. And similarly, language barrier, right? So language barrier is also another major problem with this, because the code of civil procedure code and code of criminal procedure, so they actually provide civil and criminal code proceedings in the language that has been prescribed by the respective state governments. And in fact, the All India Judicial Service would also result in, or it leads to, bureaucratization and even centralization of the judiciary. So that will not be good for the judiciary in the long term. And there could be challenges for the weaker sections who are aspiring to be part of the part of the judiciary through All India Judicial Services, because national exams actually put weaker sections, those can't afford the risk of missing out. So they actually can't afford the coachings, so thereby there is a higher risk of missing out from the judicial services. So what should be the way forward in this context? So it is important to discuss the way forward as well, because Law Commission in its 116th report, so 116th report, what Law Commission has suggested. So Law Commission has suggested appointments, postings, promotions to the All India Judicial Service by a proposed National Judicial Service Commission. So there is a need to appoint National Judicial Service Commission. So this National Judicial Commission would make appointments, postings and promotions for the All India Judicial Services, right? So in fact, the National Judicial Service Commission would consist of retired and sitting judges of the Supreme Court, members of the Bar Council, and also the legal academics as well. So thereby it would make All India Judicial Service more transparent, accountable, and also it reduce the interference of the executive in the functioning of the judiciary when it comes to appointments and promotions of the judicial officers or judges. And apart from that, cooperation is also another important aspect that is required. So cooperation among all states and high courts on the line of GST Council. So cooperation, all states, high courts, center, states would actually make the concept or the idea of All India Judicial Service a more success. And intensive training to the recruits for picking up one more language of the state to which he or she is allocated is also another major idea that has to be brought in, and that would help in overcoming the idea of language barrier. And in fact, it is suggested that the All India Judicial Service is not a panacea for all judicial issues, and there is a need of the hour is reform judicial proceedings, promoting alternative dispute resolution, and also a timely judicial appointments. So this is very important to deal with existing issues that are plaguing the judiciary. So thereby, gradually we could also think about the All India Judicial Service as well. So next is, alternative dispute resolution mechanisms. Apart from the traditional courts such as Supreme Court, High Court, subordinate courts, so there are also mechanisms which are existing to resolve disputes, right? So this is what is known as alternative dispute resolution mechanism, right? So first we'll understand what are these alternative dispute resolution mechanisms. Now, in a very simple terms, alternative dispute resolution means a procedure which is agreed and accepted by the parties of a dispute. For example, there is a dispute and there are two parties to the dispute, right? For example, the dispute with respect to the industry, and there are two parties to the dispute, party A and party B, and there is a procedure that has been proposed. There is a procedure that has been proposed to resolve this particular dispute, and in fact this procedure is acceptable to the party A and party B, and in fact there will be a neutral party, and this neutral party will assist both party A and party B to reach an agreement, and thereby there is no need to go to a court, right? So there will be an agreement that will be acceptable for both party A and party B, and this agreement is put forward by a neutral arbiter, and this agreement, if it is acceptable for party A and party B, so then it will lead to the settlement of the existing disputes in an amicable manner, and there will be no need to go to the court, and it avoids any further litigation. So this is what is known as alternative dispute resolution. I hope you have understood. So what is the constitutional basis of this alternative dispute resolution? So Article 14, so it talks about equality before law. Article 32, right to constitutional remedies, right of people to seek justice, and Article 39A, equal justice and free legal aid. So Article 39A, directive principles of state policy. And in fact, in India there are different mechanisms. There are a wide variety of mechanisms which could be part of this alternative dispute resolution mechanisms, right? So what are those mechanisms which are part of it? For example, in India we have Gram Sabha and Nyay Panchayat, Lok Adalats, family courts, counseling centers, commission of inquiry, tribunals, consumer court, Lok Adalat. So we have just discussed that, and Indian legislation on alternative dispute resolution. So all these things are part of the alternative dispute resolution. For example, arbitration, conciliation, mediation, and negotiations. So you can also go through it. So what is arbitration means, what is mediation, what is negotiation, what is conciliation? So you can actually go through it, right? This is also very important. Whenever you write an answer on alternative dispute resolution, you are being expected to draw a diagram which actually represent the types of alternative dispute mechanisms, and it would be better if you briefly explain them as well, and because of that reason, so you should go through it. And now we'll discuss the advantages of the alternative dispute resolution. So what are the advantages of this alternative dispute resolution? And in fact, Law Commission has suggested in its report 222 report, the report named Need for Justice Dispensation. And in this report, Law Commission has clearly suggested that alternative dispute resolution is less expensive, it is less time consuming, hence it will lead to speedy dispute resolution. So instead of traditional method of litigation, ADR would be a better way of solving issues between different parties. So Law Commission has clearly said that alternative dispute resolution is a more feasible way of resolving issues in a time bound manner, and it is also lesser expensive as well. So therefore this could be the first advantage of the alternative dispute resolution. Secondly, alternative dispute resolution is free from any kind of a technicalities. So there will be no technicalities. For example, civil procedure code, criminal procedure code, Indian penal code, right? So it actually having no such technicalities. It is more flexible based on the acceptability of both the parties which are involved, and it is also more responsive to the individual needs of the parties or the people who are involved. So thereby this could be another big advantage of the alternate dispute resolution. And in fact, ADR would result in a continuing relationship, because there will be no feeling of winning and losing among the parties, and this could be mutually beneficial for the both parties who are involved, right? So whenever grievances are getting redressed, so it could create a feeling, it will not create a feeling of winning or losing among the parties. And in fact, a greater compliance of the award that has been given by the neutral arbiter of ADR, because parties' involvement in the process creates a greater commitment to the result, so that compliance is more likely, and it would also result in saving crucial forex reserves, because a significant amount of forex reserves are lost on arbitration in foreign countries like Singapore. So these are the advantages of the alternative dispute resolution. However, it also has a set of limitations as well. So what are the limitations that it has been facing? Firstly, there is a lack of awareness among the people, lawyers, judicial officers. So they are largely unaware about the mandate to transfer cases to arbitration and conciliation, and that's why the potential of arbitration and conciliation in India is still underutilized. Secondly, there is still skepticism about the process and result of this arbitration and conciliation, because many litigants are not satisfied and they are invariably disassociate themselves and go to the formal courts for resolving their disputes, right? So in a way, this leads to delayed proceedings, and this leads to increased pendency of the cases and not utilizing the potential of the alternative dispute resolution mechanisms. And even there is also a criticism that decisions are actually forced on poor people and women, right? Because they are very often at the disadvantaged position, and there is a probability of decisions are being forced on poor people. And in fact, it is a voluntary process. Making all parties agree to an arbitration agreement is a very difficult task, so it's not easily done, right? So in fact, there will be a neutral arbiter. So unsatisfied party invariably blames the arbiter of bias or non-fairness, right? For example, if imagine that there are two parties, and award favors one particular party, and the other party starts criticizing the neutral arbiter for its biasness, for a lack of fairness in delivery of this judgment. And in fact, non-resolution of disputes except for arbitration, ADR process may not always yield a resolution. So this is also further leads to delay in delivery of judgments, and there will be no chance for appeal when it comes to the alternative dispute resolution, right? So unlike courts, for example, if High Court pronounces a judgment, so that particular judgment can be appealed in the Supreme Court, But in the alternative dispute resolution technique, there is no chance for appeal in higher court. And in fact, the decision of a neutral arbiter cannot be appealed in the courts. So this could be another major limitation of alternative dispute resolution. So therefore, what could be the way forward in this context? Right? So the way forward is that there is a need to incorporate tools like e-lok adalat, and there is a need to further expand the scope of free litigation as well. Similarly, promote arbitration and reconciliation as a better avenue or better career option for the people by creating trained arbiters, mediators, and there should be a procedures for quality control, ethical standards, accountability of arbiters. So therefore, there is a need to promote this arbitration and reconciliation as a career option. And similarly, reducing judicial pendency, because in 46% of the pending cases, government is considered as a litigant. So thereby, opting the ADR mechanism by the government can actually unburden the courts and build a culture of ADR in India that comes with several advantages and benefits. And similarly, there should be a coordinated efforts by judiciary, lawyers, government, center and state governments, and litigants to create a conducive ecosystem for mediation. And there is a need to expand the scope by establishing arbitration and mediation centers for even non-commercial purposes as well. And similarly, there is a need to change attitude of the people with respect to arbitration and reconciliation. And therefore there is a need to bring people to choose ADR mechanisms with confidence and trust. And there should be other measures that have to be adopted, particularly infrastructure creation for alternative dispute resolution, skilling of lawyers in alternative dispute resolution, providing required manpower as well. And in fact, arbitration and reconciliation bill has to be enacted, to fill the legislative lacunas. So all these measures have to be adopted to make alternative dispute resolution a resounding success. So that's all in this lecture, and thank you so much. So in coming class we will discuss some more important topics, and thank you so much.